distinguished guests, please take your seat. Professor William Swadling, Jeffrey Cheah Professorial Fellow, Brasenose College, University of Oxford, and Professor of Law, University of Oxford. Professor Dato Elizabeth Lee, Chief Executive Officer of Sunway Education Group. Yang Arif Dato Lee Swee Seng, Federal Court Judge. Yang Arif Dato Lim Chong Fong, Court of Appeal Judge. Yang Berbahagia Dato Sri Mariana Yahya, Retired Court of Appeal Judge. Distinguished members of the judiciary, the legal profession, colleagues, students, ladies and gentlemen. Good afternoon and salam sejahtera. On behalf of Sunway University, it is my great pleasure to welcome you to another lecture in the Jeffrey Cheah Distinguished Speaker Series. We are indeed the most happening campus. We just had one yesterday, and we have another one today. Today's event again reminds us that universities are among civilization's greatest institutions. They preserve the wisdom of the past, challenge the assumptions of the present, and prepare societies for the future. They are places where ideas are tested, not by popularity, but by evidence, debate, and reason. If science asks how the world works, the law asks how society should work. And perhaps no institution has done more to shape civilized society than the rule of law. It is therefore wonderfully fitting that today's lecture begins with a question that sounds almost ordinary. Why should I have to repay a mistaken payment? Now, I suspect everyone here had the exact same thought when they saw that title. And your answer would have been, well, that depends. How much money are we talking about? If it's RM 20 ringgit, we probably transfer it back immediately and feel great about ourselves. But if it's RM 20 million, perhaps we'll call our lawyers first. Fortunately, and perhaps unfortunately for anyone hoping to keep that money, we have invited one of the world's foremost authorities to explain why the law may have other ideas. As many of you know, I'm a cancer geneticist, and in genetics, we spend our lives worrying that changing one letter in our DNA can change a person's future. Lawyers, it seems, have discovered their own form of mutation. Instead of changing one letter, someone changes one digit in a bank account, and suddenly everyone has a legal problem. The reassuring difference is that Professor Swadling can probably fix that one far more quickly than I can mine. And today's lecture represents something much larger than the visit of an eminent Oxford professor. It reflects a vision. Our founder and chancellor, Tan Sri Dato Sri Dr. Jeffrey Cheah, has always believed that great universities are built through enduring partnerships with, in fact, the world's finest institutions. He always says, to be the best, you have to learn from, collaborate with, and compete with the best. Tan Sri's election as an honorary fellow of Brasenose College, Oxford, recognizes that it's not just his philanthropy, but also his lifelong commitment to education for public good. And from that relationship emerged the Jeffrey Cheah Professorial Fellowships at Brasenose College that links Sunway University with Oxford through research collaboration, scholarly exchange, and the annual visit of distinguished Oxford academics. These fellowships ensure that ideas travel freely between Oxford and Sunway. And fortunately, unlike mistaken payments, they always arrive exactly where they are intended. Our speaker today scarcely requires any introduction within the legal circles. Professor William Swadling is the Professor of Law at the University of Oxford and the Jeffrey Cheah Professorial Fellow of Brasenose College. And his scholarship has fundamentally shaped modern understanding of property law, restitution, trusts, and unjust enrichment throughout the common law world. His books are read by students, relied upon by practitioners, and cited by judges, which, if you think about it, it's every academic's dream. Most of us are simply delighted when people read our papers. Prof. Swadling has judges quoting his. So, ladies and gentlemen, please join me in giving a very warm welcome to Professor William Swadling to deliver his lecture.
Well, thank you very much. This is not my first visit to Sunway. I came here about 25 years ago, and it was just Sunway College in those days. And there was no Sunway University, and the difference is just amazing, really, from what I saw then and what I see today. So you should all be very proud of what's been achieved in those 25 years. So, as Prof. Abbey said, my title is Why Should I Have to Repay a Mistaken Payment? And my colleague, Andrew Burrows, who's now Lord Burrows, a judge on our Supreme Court, he just said, well, it's obvious. What do you even ask the question? But I don't think it's unobvious. We think it's obvious. We in our gut, we think, oh, yes, I should have to repay. But when you think about it a bit more deeply, it's not obvious at all. And so what I want to talk about is the standard English case on mistaken payments, a case called Kelly and Solari, and look at some of the reasoning in that case as to why the court thought mistaken payments had to be repaid, and then why we might think, well, we need a bit more to understand this. So what happened in Kelly and Solari was that you have a woman's husband died. He had an insurance policy, and so she made a claim to the insurance company on the policy, and the insurance company paid out on the policy. And then they discovered, oh, hold on a minute, the silly husband hadn't kept up his life insurance premiums. And in fact, the policy had lapsed, and someone in the office had written on the policy, lapsed. And yet they still paid out. And they said, oh, we made a mistake, the idiot clerk in the office. We've sacked them, and now we want our money back. And she said, well, I didn't know my stupid husband hadn't paid up the policy. When I made the claim, I was perfectly innocent. I was acting in good faith, so I don't have to give it back. I didn't do anything wrong. But the court said it doesn't matter. You've got to give that money back. And then the question is, well, why do you have to give that money back? Now, the next question is, well, why is that a difficult question? Why am I bothering to spend an hour talking about this? Well, normally, to incur some sort of civil liability, you have to have a contract. You have to have not met your promise. You must have breached your contract. Well, she didn't have a contract. There was no contract under which she undertook to repay the money, nor did she commit any civil wrong. Yeah, if she knew the policy was void, if she deliberately made a false claim, then yes, that would be a civil wrong. That would be the wrong of deceit. But she was perfectly innocent, so she committed no wrong, she made no contract, and yet still the law said, you've got to pay that money back. And for many years, and certainly when Kelly and Solari was decided in 1841, we said, well, it's like there's a contract. She's liable as if she had contracted to pay that money back. And this subject used to be called quasi-contract, which is a very, very unhelpful title. Because if we say, well, she's liable in quasi-contract, all we're saying is, well, she's liable as if there were a contract, but there's not really a contract. So we're not giving you a reason. If I told you that I just went out today and bought a new pet for my children are grown up, but let's imagine they're little children. I bought them a new pet, and I said to you it was a quasi-cat. You have no idea what it was. You think, is it a dog? Is it a snake? Is it a tiger? You wouldn't know, but the one thing you would know is it's not a cat. A quasi-cat is not a cat. And so if we say she's liable in quasi-contract, all we're saying is she's liable as if there were a contract, but there's not a contract. So it's not really giving us much information. I remember when I was an undergraduate law student and we studied contract law, the textbook we used was Cheshire in 5 Foot, and the editor was Michael Firmston, who was a professor here. In fact, I had dinner with him a few years ago here when I was over in KL doing some teaching. And I remember saying to my contract lecturer, we never talk about chapter 14. We never talk about quasi-contract. Why not? He said, don't go there. Don't go there. It's not contract. And he was right. It's not contract. So what is it? If it's not contract, which is forcing her to repay, well, what is it that's doing so? Nowadays, we talk about, we've given up the language of quasi-contract. We think that's totally misleading, and that's true. And now we talk about restitution of unjust enrichment. So then the question is, well, why was this an unjust enrichment? And more importantly, why does she have to pay, given that she didn't commit a wrong, given that she had no contractual obligation to pay? First thing we need to do, though, is get rid of a distraction, and that is fault. She argued, remember, she said, I shouldn't have to repay, I shouldn't be liable because I wasn't at fault. It wasn't unconscionable, she said, for me to keep the money. And the court said, we don't care about your fault. This is what Baron Park said. He said, if it is paid under the impression of the truth of the fact which is untrue, it may be recovered back, however careless the party paying may have been in omitting to use due diligence to inquire into the fact. In such a case, the receiver was not entitled to it, nor intended to have it. So the court is saying here, there's fault at two possible levels. There's a fault of the insurance company, because remember, they knew the policy had lapsed and the clerk had negligently admitted that when he was reasoning whether or not to pay. So there was negligence on the part of the insurance company, and there was no fault on the part of the widow. But the court said, well, if you paid by mistake, then what we're focusing on either is your intention, you, the insurance company, didn't intend to pay, or we're focusing on her entitlement. She wasn't entitled to receive. But either way, fault doesn't come into the question. Fault is irrelevant. So this is a strict liability claim in unjust enrichment. So then the question is, all right, if we put fault to one side and we say fault is not fault on the part of the insurance company doesn't disqualify them, fault on the part of, lack of fault, sorry, on the part of the widow doesn't insulate her from the claim, what is driving the liability? What is making her liable? Well, as I said, Baron Park gives two different explanations. He said, well, first of all, she wasn't intended to have it. And secondly, she wasn't entitled to receive it. So those are the two possible explanations. And in fact, that is the divide currently between the common law and between the civil law. In common law systems, we focus on the intention of the payor. Did the payor intend to benefit the payee? Whereas civilian systems, France, Germany, China, they ask, was there an entitlement to the payment? And what you see in Baron Park's judgment in Kelly and Solari is both, actually. He's talking about she wasn't intended to have it, nor was she entitled to receive it. So then the question is, well, do either of those things justify ordering her to repay? So if we start with not intended to have it, here the argument is that the insurance company made a mistake. Their intention to transfer was defective because there was false data in their head. And we call this a species of vitiated or defective consent. And then the question is, okay, well, we're not disputing that. They didn't fully intend her to have the money. But does that justify her being liable to be ordered to Repay. And Peter Burks, who was the doyen of English unjust enrichment lawyers, he, like Lord Burrows, thought it was just obvious. And he gave an example of someone who walks into a shop and they offer a £20 note, and then the shopkeeper makes a mistake and gives them change for a £50 note. And then they walk to the door, and just as they get to the door, the shopkeeper says, oh, I made a mistake. I gave you too much change. Give me back. And this is what Peter Burke says. Here, you may be tempted to insist, you're the customer, that you are entirely innocent, but you will immediately see that a retort of that kind will not strengthen your case to keep the £30 overpayment. Your innocence is irrelevant. So long as you still have the mistaken money, there is no answer to the shop's demand to have it back. Okay, so there's no answer, said Professor Burks, to the shop's demand to have this back. Well, the trouble is, that's just an assertion. He's not telling us what the reason is. He's just saying, well, whatever the reason is, you can't answer the reason. And he said that time and time again. For example, he says this proposition barely needs authority, and there's no convincing argument why a mistaken payee should be able to keep it. And as I said at the beginning, that may be our intuition, although as Prof. Abbey says, if it's 20 million ringgit rather than 20 ringgit, you might phone your lawyer first. Do I really have to give this back? But I think our intuition is, I should. But then the question is, well, why should the legal system intervene and order you to do so? And the real problem is that even if we can focus on the lack of consent to the transfer, we still have to connect that argument with the widow in Kelly and Solari, the recipient, the payee, because they've done nothing wrong in receiving the money. Why should they, even if the payor was making a mistake, why should they be the one that has to sort of somehow make things better when all they did was passively receive? And unfortunately, Professor Burks' argument doesn't address that link, that connection with the payee. Why should the payee repay? We can see why the payor thinks they have a claim, but what we still haven't done is explain why that puts the payee on the hook. And then before we try to make some connection, as I said, Baron Park in Kelly and Solari said, well, there is a second reason why Mrs. Solari has to repay the money, and that is she was not entitled to receive it. And in fact, as I said, that's the civilian approach. That's the approach you see in France, Germany, China, many other jurisdictions around the world. And that is also a view that Professor Burks moved across to. He moved across from the English approach, the common law approach, which is very much looking at specific reasons why an enrichment is unjust, such as mistake or duress or undue influence or something like this, towards a system where we talk not about unjust enrichment, but about unjustified enrichment. That enrichments need a justification, and if there is no justification for that enrichment, then you have to give the money back. And as I said, in Kelly and Solari, you see both of these ideas in play. And then the question is, well, why? Why should the fact that she was not entitled to the money mean she has to give it back? Well, she certainly had title to the money. The company, the insurance company, handed it over to her and said, this is your money now. So title to the money passed from the company to her. So it's very difficult to see why she was not entitled to it. What you might say is that she had no entitlement to receive the money. that somehow you needed an ability to sue, and she had no ability to sue. If the insurance company had not paid and she tried to sue them, she would have failed because the policy had lapsed. And so maybe what we're saying is, well, you can, if you have no ability to sue to receive a benefit, well, then you can't keep that benefit. But we know that's wrong because we have a law of gifts. If I promise to give you a birthday present, and then I don't give you that birthday present, you can't sue me. There's no consideration for my promise. So you have no entitlement to that money. But if I give you the money, say, happy birthday, here's 1,000 ringgit, I can't get it back simply because I can't go to court and say you weren't entitled to receive that money. The court says it doesn't matter. The common law doesn't have a requirement of entitlement to receive. And so when Baron Park says she wasn't entitled to receive it, that just doesn't work. It wouldn't work in any legal system which recognized gifts. The other problem for a common lawyer is we don't really know what the list of entitlements would be if we were going to move across to a system where it's based on, can you justify the enrichment? Well, what are these justifications? We have no idea what they are. We have no list of what civilian would call a legal basis. And they talk about, oh, was there a basis for the payment? And if there was an absence of a basis, you can recover. Well, we don't have a list, so we can't operate that system. Also, that system doesn't seem to have, certainly from my perspective, any normative bite, as it were. So a typical example would be a case where I enter into a contract with you to sell you my house. And we agree a price, I transfer the house, you transfer me the money, but our contract is void because in English law, and this was a mistake that the English Law Commission made back in 1989, but the Parliament adopted it. In English law, we have a rule that a contract for the sale of land is void unless there is signed writing on both sides. And in the example I'm giving, there wasn't any signed writing. But nevertheless, you got the house, I got the money. And then let's say later on, the market suddenly rises. And it turns out I made a really bad deal. Can I then say, oh, well, there was no valid contract, there was therefore no legal entitlement for you to receive the house, give it back? Well, that would be crazy. And English law certainly wouldn't allow that. In English law, we would simply say, well, you got everything you bargained for. You can't complain. But in a system which said, no, we're looking for entitlement to receive, and we're looking for a legal basis, then it would seem that that transaction would have to be unwound, and there'd be no merit whatever in my claim. So English law still sticks to what we call unjust factors approach. We're still looking for specific reasons why the court should intervene, such as mistake or duress or undue influence. We haven't moved to this entitlement regime. So going back to the unjust factors approach, to the English approach, then the question is, well, can we somehow connect the defendant with the plaintiff's vitiated consent? Because we need to bring them into the picture. And this often is just overlooked. As I said, Professor Birks doesn't address this issue. Professor Burrows, in his book, doesn't address this issue. There's a very famous Canadian legal theorist called Ernest Weinrib who does, and this is what he said. He said, a claim for a restitution of a mistaken payment does not deal with a benefit in the air, but with the subjection of a particular payee to the payor's claim. The basis for requiring the payee to make restitution to the payor must therefore apply to both parties. that the payor gave the gratuitous benefit without donative intent is not in itself a reason for holding the payee liable. What the unjustness strand needs is a second aspect connecting the payee to the basis of the payor's claim. So that's what we have to now turn to. Can we find this second aspect, this connection between the payor's lack of intention to benefit and the fact that the court will order the payee to basically make good the payor's mistake? And there seem to be about at least 5 different arguments as to what this connection is. How do we connect the lack of intention on the part of the payor with the fact that the court will intervene and order the payee to make good that error on the part of the payor? And the most common, the first, is when we say, well, it doesn't leave the payee worse off. This is the no worse off argument. Well, straight away, that can't be true, because if you think about the example in the shop, you've got an extra £30 in your pocket. And if the court now orders you, take £30 out of your pocket and pay it over to the payor, well, you are worse off. You're £30 worse off than you were before the court order was made against you. So it's not obvious that you're no worse off. You're no worse off if you go right back to the beginning of the story, but you're not worse off at the point when the court order is made. At the point when the court order is made, you will be £30 worse off, or however much money was paid by mistake. You will have less opportunities available to you than previously were there. So the no worse off argument on its own doesn't really work. Some people have said, oh, we can explain this in terms of property. And this is what an English colleague, Peter Jaffe, says. He says this: because the money transferred belonged to the payor, it is implicit in her right of ownership that she should be able to recover the money or its value from anyone who received it other than through a valid exercise of his or her power as owner to transfer it. Okay, so it's all to do with the fact that in our shopkeeper example, or the insurance company example, the plaintiff owned the money at the beginning, and somehow the fact that they own the money at the beginning gives them a power to get that money back, unless it was transferred through a valid exercise of his or her power to transfer it. Well, this doesn't work either. First of all, there was a valid exercise of the power to transfer it. If there wasn't a valid exercise of the power to transfer it, then title wouldn't have passed. But title did pass. That's why we're bringing the claim, because title passed. If title didn't pass, well, then you could bring a claim in tort. You could say, that's still my money, and you're committing a wrong if you don't give it back. But no, we're not accusing her of any wrongdoing. In fact, if the payor just went and put their hand in the pocket and took the money back without a court order, they would be committing a wrong. They'd be committing the tort of conversion. They'd be committing the crime of theft. So this was a valid exercise of the power. You can't say it's a valid exercise of the power because otherwise property wouldn't have passed. But it did. So this is completely circular. Basically what we're saying is, well, she's entitled to, the payor is entitled to recover it from the payee because the payor is entitled to recover it from the payee. We're not actually providing any valid reason. Also, it wouldn't work even on its own terms. Even if this theory made some sort of sense, it wouldn't work outside transfers of rights. So, for example, it wouldn't work in the case of a mistaken service. If I mistakenly improve my neighbour's land, well, there's no ownership, there's no property which is passed from me to my neighbour. So the property analysis wouldn't explain recovery, and yet we know recovery is allowed in certain circumstances like that. It also wouldn't work in the case of bank accounts. Most restitution cases concern bank accounts, because we talk about a bank transfer, but actually there is no transfer in the case of bank accounts. All that happens is one account is debited and another account is credited, but no rights actually move across from one to another. And yet 99% of restitution cases concern bank, inverted commas, transfers. So the property theory doesn't work either. Another theory is that, well, what we can do is we can add in some other factor to the fact that there was a mistaken transfer, and that extra factor somehow justifies recovery. So some people say, well, what happens in these cases is that eventually Mrs. Solari will find out that she was paid by mistake. Okay, Mrs. Solari, on the facts of the case itself, had no idea at the point of receipt, but later on she find out because the insurance company issues the writ against her and says, pay us back. And somehow, once she knows that there was a mistake, that justifies the claim. But simply knowing that someone has a claim against you doesn't somehow give that person a claim against you. Knowledge on its own that there is a possible claim cannot suddenly create a claim which didn't exist before that knowledge supervened. So that can't work. Simply adding in knowledge of the claim can't give you a valid claim. It presupposes the very thing it's trying to prove. People sometimes say, oh, well, it's all about retention. It's all about receipt plus retention. That you received whatever the money was, and then you retained that, and somehow retention of the money justifies a claim. But again, that doesn't explain anything at all. It may be we want to say that you need to retain the enrichment before you can be liable, because there's the worry about what if Mrs. Solari spent the money on a holiday or gave it to charity, and then they come after her and she says, oh, well, look, you know, I've changed my position in reliance on the fact that I thought this was a secure receipt. You know, she's now the merry widow and she goes on a cruise hoping to meet a new man or something like this. Somehow she says that I wouldn't have done that had I known that you guys were making a mistake and I'd have to give this money back. Making me pay now is actually unjust on me. And today, since about 1992, we have in the common law a defense of change of position. Now she would have a defense. She didn't have in those days. So we might think, well, she needs to have retained the enrichment to justify bringing the claim, but that would be unnecessary, but surely not a sufficient condition. Retention of the enrichment is neutral in telling us why a claim should be able to be brought. And then finally, remember Weinrib said you need this connecting factor, this extra connecting factor. He's the only one who's really spotted this. He then supplied one. He said, right, and I've got the connecting factor. And he said this. He said, it's the connecting aspect is the payee's acceptance of the benefit as non-gratuitously given. The payee's acceptance of the benefit as non-gratuitously given. He said that would explain a case like Kelly and Solari. In Kelly and Solari, she accepted the payment as non-gratuitously given. So then the question we have to ask is, well, what does that mean to say the payment was gratuitously given? And what does it mean to say that the payment was accepted? And this is what Weinrib says about those things. He says, except when the enrichment was intended and accepted as a gift, the payee can be regarded as assuming that no benefit is given gratuitously, even if the payee has not turned his mind to this issue. Private law is a legal regime through which parties act for their own purposes without subordinating to others their freedom or the means for realizing it. One can therefore impute to those who interact within this regime awareness that any benefit received from another was not intended to be given gratuitously. Accordingly, enjoyment of a benefit for which one knows that no equivalent was exchanged carries with it acceptance of the benefit as non-gratuitously given. Now, I don't think this works for a number of reasons. The first objection, the first problem is that it doesn't explain the mistaken gifts. In the common law, you can, in certain circumstances, recover a mistaken gift, and yet you know that a gift, mistaken or not mistaken, as far as you're concerned, the recipient, it is gratuitously given. You can't say, oh, well, this was a non-gratuitous gift. That's a contradiction in terms. Another objection is that people don't operate within the legal system. You know, people in the street are not thinking, oh, yes, I'm operating within the private law legal regime, and so I better think like a lawyer. Most people aren't lawyers. You know, they don't have a copy of Goff and Jones on restitution, or Burroughs on restitution, or Burke's on restitution on their shelf. We don't teach this in high school. So it's just crazy to think people think like lawyers and think sort of that no one does things non-gratuitously. The other problem is that Weinrib has a very broad definition of accept. You know, all Mrs. Solari did was made a claim on the policy, and then they sent her a check. It's very difficult to say that she accepted that payment as given non-gratuitously. I think all we can say is, well, she was benefited by the payment, but that's just part of the constituent elements of the claim. You have to be enriched before you can be unjustly enriched. But simply being enriched is not a reason why you have to pay that money back. As I said, it might be different if she lied, if she knew the policy was void and yet she nevertheless went along and claimed, or something like that. But in that case, you might say she was somehow responsible for their mistake. But in this case, she wasn't responsible at all. They were responsible for their mistake, and yet she's the one that's having to make good their error. So I don't think the Weinrib explanation works either. And then we've got a problem, because we do have a law of unjust enrichment. We do have a law which requires mistaken payments to be repaid. And it's not just England, Singapore, Malaysia, Hong Kong, Canada, US. Every country in the world, at least every system I know of, says people have to repay mistaken payments. But why they have to repay a mistaken payment is something I, at least, unlike Lord Burroughs and Professor Burke's, I at least struggle with this question. Thank you.
Thank you, Professor Swadling. Today's lecture was a perfect example of how the finest scholars possess a rare gift. They don't need PowerPoint slides like a geneticist. They take questions that appear ordinary and reveal extraordinary principles beneath them. And thank you for reminding us why universities matter, Bill. Today's lectures was never really about mistaken payments. It was about mistaken assumptions, about justice, about reason, about how societies choose principle or not over convenience. As Oliver Wendell Holmes once observed, that life of the law has not been logic, it has been experience. And this afternoon, you've shown us that the finest legal scholarship combines both and a lot of words. I suspect that we have all learned two things today. First, the law is considerably more elegant than we imagined. And the second, if unexpected money ever appears in our bank account, our first phone call should probably not be our financial advisor, but to Professor Swadling. So, Professor Swadling, thank you once again for a truly outstanding lecture, and let's give him a huge round of applause. But great lectures deserve great conversations. And the hallmark of an outstanding moderator is not having all the answers. It is asking the question that everyone else wishes they had thought of. And we are indeed very fortunate today to have precisely such a moderator. Sunway University's adjunct professor of practice, Marianne Ui Swan Kim, or Kim as we lovingly call her, is one of Malaysia's most respected legal practitioners, educators, and thought leaders. As a dual qualified UK-Malaysian barrister and managing partner of OS Kim and Associates, she has spent almost 2 decades navigating complex regulatory, commercial, and civil disputes, and has won multiple international awards for her body of work, including the UK Alumni of the Year Award for her outstanding professional achievements and her various contributions. And Bill, if I continued with all the list of her achievements, I think both of us will suffer from imposter syndrome. Because beyond practice, she's deeply committed to legal education through her role now at Sunway University, UKM, and at the University of Sheffield. She has built a reputation for connecting academia with practice, intellectual rigor with commercial insight, and legal scholarship with real-world impact. And most importantly, she's a Sunway alumna, truly a class above. Professor Swadling has challenged us, how should we think? And Kim's job now is to challenge Professor Swadling. And knowing Kim, she's going to make you sweat. So without further ado, the floor is yours, Kim.
Thank you very much, Prof. Abi. How do I send that out? Thank you. Thank you very much, Prof. Abi. Distinguished guests, honorable judges, ladies and gentlemen, it was such a delightful treat listening to you speak, Professor William. I think what we can bring back home today is going deeper whenever we come across monies which may appear at different moments in our life. Windfalls, if you will. A lot of thoughts came over me as I heard you speak with such passion, and how all of these examples, even the case that you gave, 1841, it still resonates up till today, 2026, and moving beyond. What we would like to hear from you, Bill, is what are your thoughts for today's complex regulatory systems? Because we have huge and vast amounts of money moving in and out of economies, of countries, and in this complex world of anti-money laundering. What are your thoughts in terms of the current regime? How do we get more acute and more aware in our everyday lives? So what's your advice to us, Bill?
It's a big question.
It is.
Especially since every legal system is different, and we're talking about money moving across borders. But there is a lot of fraud out there, and a lot of very innocent people being scammed by phone calls and people saying this is the police, or this is some romantic scam. There was a big case in England just recently where there was a class action actually where all these women who'd been duped into paying hundreds and hundreds of pounds to these scammers, who I think were based just not far from here, not in Malaysia, but near the Chinese border, and there must be much more regulation to try to stop this money laundering going on and somehow have redress for these scams. One thing that's that's happening, I don't know what's happening in Malaysia, but certainly in England, that the banks are getting much more cautious in allowing bank transfers to happen. They always, because in a lot of these cases, the banks were on the hook because of the way the bank account was structured. In fact, it was the bank that was paying out because the customer could recover against the bank. So the banks are now installing, and if they couldn't, they were then negligence cases saying you should have protected us, which were at some level succeeding. So what the banks have now done is introduce systems where you're having to say, yes, I really do intend to pay this money, and I really do think this is a genuine transfer, and I know that if I don't make the transfer, that if I do make the transfer, I can't chase you, the bank, anymore. And hopefully that is helping in some way, but I haven't seen any empirical evidence so far.
That's really interesting, because what I find, Professor William, what is happening in Malaysia, there's a lot of disputes centering around everyday lives. You know, like recently I had my credit card being charged just like $25 US, $30 US, 25, 22, 10 in a series of transactions. And then when I called the bank, I informed them, they said, well, you've got to go through a lengthy process, you know. It's not that we don't believe you, but we have processes in place. Very well, fair enough. But it took a long time for the money to be credited back. So what are your thoughts on that? Could these kind of systems be improved?
Well, certainly.
Yeah.
My advice would change your credit card company because, and tell them why you're leaving, because that's dreadful. Sometimes it works the other way around. I get my credit card stopped when I'm trying to actually use it because they say, oh, this is a suspicious transaction because it's only $25. Nothing costs $25 anymore.
It's a series, it's successive series of $25. And I was shocked.
Yeah.
But would that be a better option for the banks, you think, if they notice it? So whose onus is it, for the financial institutions or for us, everyday public, to be aware all the time?
My credit card, as I said, they're very, very active. And there has been a few ones where they've stopped it, and they're very, very good. You just phone them up, and I say, there's something wrong here, and they say, oh, yes, we'll credit you straight away. So I'll tell you later what the credit card company is.
Very well.
I shouldn't advertise.
Great. Which brings me to the next segment, Prof. William. So earlier on, we started with Kelly and Solari, 1841, right? Now, there are two parts of this. Does the Commonwealth jurisdiction necessarily coalesce with the civil law jurisdiction in terms of unjust enrichment and restitution, if you will? So had Kelly and Solari been a 2026 case, which is in UK or in, say, France, would the outcome be any necessarily different? Your view?
Yeah, well, Kelly and Solari is the easy case, as it were. That's the one where English law would, despite Professor Burke's moving across to the French way of thinking, the English judges haven't, so far at least, but they keep saying, well, maybe we will, maybe we won't, but we're not closing it off completely. But the mistaken payment is the very simple case for both systems, because in English law we'd say, well, the insurance company made a mistake, so the enrichment was unjust. In France they'd say, well, there was no basis for the payment because the contract was void. So in both systems you'd have to give the money back. The difficult case, the one I mentioned earlier on, is where money is transferred pursuant to a void contract. And in English law, we had a whole series of cases about void contracts. This was the swaps litigation. We had these interest rate swaps where local authorities were using it to raise money. And it turns out that an interest rate swap is perfectly valid between you and me, but it's not valid if you're a local authority because you have limited powers. And so these contracts were void, and yet millions and millions of pounds were being transferred pursuant to them. And then there was some judicial review action which went to the House of Lords, and the judicial review action said these contracts are void. So suddenly everyone's saying, oh my God, I want my money back, because I can't sue on these contracts, I can't enforce these contracts, so I just want to unwind these contracts. And in a civil law system, we say, well, that's easy, because it's a void contract. There's no entitlement to what you received. The enrichment is unjustified. But in English law, as I said, we don't have that system. We have a system which says instead, well, you have to point to some specific reason like mistake or duress or undue influence or failure of basis. And it was problematic because, first of all, in those days, the only mistake that would count was a mistake of fact. Whereas these were mistakes of law. These were the mistakes about, was this a valid contract? And there was a huge question of interpretation of public law, which had to go to the House of Lords. And so in one case, the courts changed the rules and said, actually, no, you can now recover for mistakes of law. But then another problem was, well, was there really a mistake in these cases? And that's still bubbling under, because if I'm entering into this contract with you and we've got no cases telling us that these contracts are void, all we're doing is thinking, well, if this gets to court, the court will strike it down or the court will uphold it. But we're predicting not the present state of the law, because there isn't any law. We've got a statute which no one really understands. We need the judges to tell us what it means. But then we don't know what the judges are going to say. And in fact, in the judicial review case, the High Court judge says these contracts are void. The Court of Appeal judges said these contracts are valid. And then the House of Lords said, no, these contracts are void. So the law wasn't clear. The Court of Appeal weren't idiots. They were very clever judges.
Absolutely.
But they just got it wrong. But who knows whether they got it wrong until the House of Lords told us they got it wrong. That's the way the law works. And so there was a big argument, which is still rumbling on, that there wasn't a mistake in those cases, because there's no existing law to look at, and there was no false data in the head of the contracting parties. So those cases are really difficult for a common law system, but apparently quite, and I have to confess to not being an expert in the French law of unjust enrichment. I don't even speak the language, let alone speak the law. But for a civilian system, those decisions are seen as quite easy. So that's the difficult one.
So the vitiating factors. But I from what I can tell, knowledge is probably irrelevant. Timing of the knowledge may count as relevancy. The intention bit is important. The knowledge, when do you know that it's mistaken from both sides? That is probably relevant at that point of time. Your thoughts?
Well, there's a debate at the moment which is going on both in England and certainly also in Australia. I've just come from Melbourne, where I was teaching an intensive LLM course. And the Australian courts certainly say that if I pay you money by mistake, you've got to pay it back, which is not controversial, apart from what I was saying a minute ago. But what they also say is, and if you knew or later on realized and you still had the money at that point, then you hold it on trust. And then if you hold it on trust, well, then you beat the insolvency, the plaintiff doesn't have to worry about the insolvency regime. The plaintiff can go against third parties who receive the money from you. You can then trace the money into substitute products. All these bells and whistles that attach to express trusts suddenly arise when you know there's a mistake. And what's not happened is anyone's explained why knowledge of the mistake suddenly elevates my claim from an unsecured creditor to someone who's actually better than a secured creditor. Just because I give you a phone call and say, oh, Kim, I paid you money by mistake. Bang, I get bumped up from economy to first class just by a phone call.
I love this. The intersection between contract law, trusts law, equity, and property. So, Professor William, earlier on you were talking about property, right? Well, we are acutely aware that in Malaysia we have the National Land Code, so we don't adopt the English property law system. However, there are, of course, many similarities between the two systems. What are your thoughts? Because earlier on you gave a very good example about giving money over, having the property, the benefit of using the property, and then realizing the other side realizes, hey, yeah, actually, I probably sold it too cheap. Or the other side now reneges, afterthought, oh no, I think I probably want to change my mind. So then, is that a mistake? Would that qualify as a mistake?
Yeah, well, certainly that's a very good question. The first thing we do when we teach the law of mistake is you've got to figure out, well, what is a mistake? And the distinction is between a present state of facts and future state of facts. And so here the example is we don't realize that the market is going to suddenly take off or the market's suddenly going to go down, because it may be the purchaser wants to get out of this because the market has dropped. So we say, well, no. What we're talking about there is a misprediction. A prediction as to the future is not a mistake. A mistake can only be a mistake as to something which is present, either a mistake of the present facts or a mistake of present law. So we wouldn't allow recovery in that scenario under the heading of mistake. And that's the worry about if you then, as we've done in England, have this rule that contracts for the sale of land must be in writing, but there's no writing, and yet nevertheless people perform on both sides. If you move to an absence of basis regime as opposed to an unjust factors regime, then what you seem to be doing is opening the door to unwinding these transactions in situations where I don't think anyone thinks they should be unwound, because you've got what you wanted, you got the house, I got what I wanted, I want the money. Okay, later on, one of us is regretting having made that contract, but it was a perfectly, apart from the formality rule, it was a perfectly good deal. Yeah. And I don't think anyone would say you should be able to unwind it.
Of course. Okay, I see a lot of students in this room, and probably they have burning questions. I saw a gentleman in yellow. Just waving, but no question. Gentleman in black. Please state your name and where you're from.
Yeah, no.
Okay. Yeah.
I'm Syed Fadil from the Central Bank of Malaysia. So perhaps instead of looking at it from the perspective of unjust restitution for unjust enrichment, do you then delve into restitution for unjust losses? Because when we look it from perspective of restituting unjust losses, it doesn't really matter the knowledge or the fault on the part of the person and getting enriched. but rather from the perspective of person that is losing something. So that's why the law addressing it from the perspective of whether it's by mistake, by duress, which there is a fault there. When mistake, there is no fault, but when there is duress, there is misrepresentation, there is undue influence, there is a fault there. Regardless, the law still requires a restitution because there is unjust losses.
Okay, so I suppose one thing to begin with is we traditionally, Kim talked about unjust enrichment and restitution, and there's a difficult question as to the interrelationship between these two things, and then when we think of restitution, even that word is ambiguous because sometimes we think of restitution as compensation. If people say, I want restitution, what they mean is I want compensation for my loss. Whereas when we talk about restitution, we're talking not about compensation, we're talking about giving up gains, that please order the defendant to give up the gains. And then there are two different reasons why someone has to give up a gain. The sort of easier one is where they've committed a wrong in receiving the gains. So there's a big case going on in Australia at the moment, which the High Court there has heard, where some animal activists broke into a food, well, it's a slaughterhouse, and they filmed the processes of the company, and then they were sort of using this filming to sort of show up what was going on in the factory, and what the factory owners wanted was a trust of the copyright of the film. So that raises questions about, well, is trespass to land a wrong which generates a gain-based remedy? And then if it is a wrong which generates a gain-based remedy, does it generate a money award or does it generate a trust? And the first instance judge said, you get a money award. The Court of Appeal said, you get a trust. And that's why the case has now gone to the Supreme Court. Sorry, not the Supreme Court, the High Court. It's confusing because in England, the High Court is the lower court and the Supreme Court is the High Court. But in Australia, the Supreme Court is the low court and the High Court is the High Court. Anyway, it's gone up to the High Court. And in fact, my former colleague, Justice Edelman, is one of the judges on the case. And he wrote his Oxford doctorate on this whole question. So I'm sure he's going to be very active. Well, he was very active in talking to counsel, but he'll very, very active in writing the judgment as well. So there are cases of what we call restitution for wrongs, and then there are restitution for unjust enrichment, and traditionally we mean things like mistake, duress, undue influence. But you're perfectly right that sometimes you can recharacterize these unjust factors, as we call it, in terms of wrongdoing. Sometimes duress could be a wrong. If I hold a gun to Kim's head, it's not a real gun, and I say, hand over your money, your phone, or I'll kill you, well, clearly I commit a wrong, but we could analyze this case in terms of unjust enrichment. You could say, well, forget the fact that it's wrong. There was a defect in Kim's consent. Clearly, it wasn't a free consent. And so we have these cases where what we say is you can analyze these in one way or another. What Peter Burt's called alternative analysis. And really what we say is we give Kim the choice. If it suits Kim to bring a claim in wrongs, we allow her to do that. If it suits Kim to bring a claim in unjust enrichment, we allow that.
Or I could choose the bullet.
Yeah, it might matter for limitation purposes or for conflicts reasons or all sorts of things, but she has a choice. Yeah.
Very good. I see a question from Professor Philip Koh.
Professor, thank you for your masterful exposition on Kelly and Solari. As I listen carefully, just like to add one observation and perhaps pose the question to you. In Malaysian law, I have said to you before we entered the room, We have our 1872 Indian Contracts Act, migrated here in 1950. Some of our law committee is looking into it. It's Section 73, payment according to the mistake. We won't go into the Malaysian judicial, what our learned judges are here, but we won't pose it to them now. In your exposition, you did masterfully question what exactly does the action ground, and you question the issue of not quasi-contract, that's a bit of a fiction, kind of legal fiction. Property, not quite. This is not one of those Romapa clauses where you trace and there's a retention of title and trust and all that. And you dissected each of them. May we know your position as a professor about how would you rationalize the basis, at least in Kelly and Solari, of why this lady should pay back? Can we have your views?
Well, this is I just have this. I'm a doubting Thomas. This is my problem. That whereas Lord Burrows just has no doubts whatever, and I know Peter Burks has no doubts whatever. I just have this sort of just this in the back of my mind. I just can't make this work. I think she should pay it back. I think we should pay back mistaken payments, but I just haven't quite managed to find out why.
But could I just venture that we are into, of course, the philosophy of language to some extent. And is there some form of metaphysics, sorry for that big word, a kind of an ontology of an intuitive, use the word intuitive, uneasiness that is not quite right for her to retain it, but why? And these great Oxford professors, Lord Burrows and all that, and Burks, is having this wonderful classification, it's so clear. And even that the case about the shopkeeper. But for you, and I appreciate it not because you are the speaker, you are provoking the question, why? Why is it so clear? Just because your taxonomy, your classification make it clear? Are we playing linguistic games here that somehow made it certain and you are still curious? Perhaps it's not so certain.
Yeah, no, certainly Lord Burrows and I have always had this problem. He has another one about the trusts. So he just says, well, it's obvious you should have a trust where you pay money by mistake. And I said, why? He said, well, you shouldn't have to queue up with the insolvency. And a trust will get you out of that insolvency queue. So therefore, we should give you a trust. And I said, well, hold on. First of all, there's lots of other reasons why people might want a trust, which have got nothing to do with insolvency. So even if it works in insolvency, it can't explain what a trust is doing in all these other situations. He said, oh, well, no. I remember he once said to me, I've thought about this very hard, Bill, so I just can't understand why anyone else is querying this. I said, this is our job, Andy. This is what we do. And then the other day, the Supreme Court handed down a decision where it was a bribes case. Someone took a bribe, and under English law now, it didn't used to be, but under English law now, the person who takes a bribe holds that on trust. It's a constructive trust. And then what happened in this case was that a third party assisted the person who took the bribe to basically move the money away into a different jurisdiction. So it wasn't available to the victim of the bribe. And then this person was sued for assisting a breach of trust. And the case went all the way to the Supreme Court. No claim had ever succeeded on that basis before. And then the majority say, yes, this claim will succeed. You can assist a breach of an express trust, but you can also assist a breach of a constructive trust. And Lord Burrows suddenly said, hold on a minute. And he cited some of my writing and said, maybe this is going too far. And I think I'm sort of after 30 years of banging on at him, I think he's finally starting to realize that it's not as straightforward as he thought.
I like the defense of non-S factum. So we could probably use that. And also, there's a very simple saying, ignorance is bliss. I see a question from Chung Xiao Mei of UM.
Professor Swadling, Kim, I'm Shomei from University of Malaya. Thank you very much for such a clear lecture on this restitution, and I hope I can replicate some of it to my students. My question is, in Malaysia recently, well, not so recently, about 10 years ago, there is a federal court case, the most significant case on unjust enrichment, and it says, we recognize this as the third course of action, which is excellent for our jurisdiction. But the federal court also decided that to proceed on the absence of basis approach, which is troubling for many of us who understand common law. I have understood that common law require unjust enrichment for restitution because common law doesn't assist a volunteer, and therefore so I want to know how would you look at this decision? Thank you.
I have to confess to not knowing the federal court decision, but as I said, the English courts, they haven't finally made their mind up. The Supreme Court now and then says, well, maybe we need to move across to an absence of basis approach, but this isn't the right case. The point's not being argued. Lord Burroughs, I know, is very much against the absence of basis approach. He was appalled when Peter Burke's moved from unjust factors to absence of basis. He said to him, Peter, you spent your whole life convincing the English courts that unjust factors is the way to go, and so they went with you. You can't now suddenly pull the rug from under their feet. And so he wrote a very strong article in the Cambridge Law Journal defending unjust factors. And so I know that our court, now he sits on the Supreme Court, is probably not going to go in that direction. Singapore, I think, is still on unjust factors. I think people have tried a couple of times to move to absence of basis, and the Singapore courts have said no. Certainly in Hong Kong, the Court of Final Appeal have said on a couple of occasions, no, we don't do absence of basis. So I must read the federal court case.
Ask whether it is consistent with the common law approach to go on absence of basis.
It's difficult because in Kelly and Solari, you see Baron Park saying the same thing, saying two different things in the same sentence. She wasn't intended to have it, nor was she entitled to receive it. So it's nascent in the common law. And so I'm not sure you can say it's inconsistent with the common law approach. The real question is what's the best approach? And I have, as I said, two problems with absence of basis. And one is I don't know what the bases are. We don't have a list. Whereas in civil law systems, I remember as a student, there's a wonderful book called Zweigert and Kurtz on comparative law. And chapter 1 of Zweigert and Kurtz is called Juridical Act. I thought, what on earth is juridical act? And we just don't have a concept of juridical act. But that's what they mean. When they talk about absence of basis, they mean absence of a juridical act. So we'd have to develop a whole jurisprudence of juridical act before we can have absence of juridical act. So that's problem number one. And then the second problem I have is, as I said earlier on, I just don't see what the normative force of lack of juridical act is. I can see why we start thinking, oh, well, you should give it back because I didn't intend you to have it. But you should give it back because there was no juridical act. Seems a bit too abstract for me. And maybe that's what you mean by against the sort of common law sort of thinking, because the common law thinking is sort of quite pragmatic, quite down to earth, whereas sort of German law, French law is quite, especially German law, it's very, very theoretical. It's sort of designed by professors, whereas the common law is designed by judges and it's much more practical. And I think for that reason, it is a better system. It answers real life questions.
Thank you. Do we have any thoughts from our Apex Court judges? Justice Lee, yeah, Justice Lim, Justice Mariana. It'll be interesting to hear. Yeah, Mr. Ong.
No, I have a very much simpler question.
Okay.
We
love
because
this.
You stop short on what if the widow had spent the money without knowledge, so it has not converted to trust. That's a change of position. Would she still need to repay?
For the trust.
No, repay the
Because
full
she
sum.
spent all the
Let's
money,
say
right?
She spent 50% of
Yeah.
what she has received
Yeah.
without knowledge,
Yeah.
and therefore it has not converted into a trust, and her position has changed. She
Yeah.
don't have that much money to
Yeah.
provide a full refund.
Yeah.
So would she still need to repay? Can the court still order her to repay the full sum?
Right, no, that's a good question. So back in 1841, as Kim said, we didn't have a defence called change of position. So in those days, the answer would be yes, because in those days we still thought about it as part of the law of contract. As I said, this was quasi-contract. As Professor Koh said, we have this. We even had books called quasi-contract. And if you look in the 19th century contract textbook, half of it is express contracts, half of it is quasi-contracts. And then, so because they were seen as analogous, the same thinking applied. So that, if I lend Kim 100,000 ringgit and then the money gets stolen from her, that's no defense when I say, well, we had a contract of loan. But then if I pay Kim 100,000 ringgit by mistake, and then the money gets stolen from her, well, if we keep thinking in terms of, well, this is like a contract, we say that's irrelevant. But if we say, hold on, this is nothing to do with contract, then we might start saying that she should have a defensive change of position. And so now, once we got rid of that implied contract thinking and it was only in about 1992, I think, we finally, in England, certainly got rid of it. As I said, when I was an undergraduate student, Chapter 14 of Cheshire and Fifield still talked about quasi-contract. It doesn't anymore. Now we've got rid of it, we can start thinking, well, now we're free of contract, we can start thinking there should be a defence. And so, so nowadays, what would happen in that case in Kelly and Solari, if she spent half the money, let's say she gave half the money to charity, then she would only have to repay the other half. Yeah. But sorry?
Back then she would have to.
Oh, back then she would certainly had to pay it all back. Yeah.
Thank you very much. Does that heave a sigh of relief for some in the room? Okay. Any other questions? We see members of the public here as well, because I understand this lecture was also in the Star newspaper. I saw it. Yeah.
I have to buy a
there's-
copy.
Yes. Any questions? Students? No, we're all quite happy and confident. Thank you very much then. Thank you,
you.
Professor
Thank you.
William.
All right. Ladies and gentlemen, this afternoon, really, both of you and now, Bill, you have demonstrated that the finest legal scholarship combines both. I suspect everyone in this room has learned two things today. First, the law is considerably more elegant than we imagined. And second, if unexpected money ever appears in our bank account, ignorance is no longer a defense. You've all heard Professor William Swadling share his thoughts. And if today's lecture prevents even one person from making a very expensive mistake, then I think Sunway University has performed a valuable public service. Thank you, Kim. And certainly to Professor Swadling, thank you once again for a truly outstanding lecture. On behalf of everyone here, Thank you for reminding us that in law, as in marriage, it's often much easier to transfer money back than to, or even transfer the money than to get it back.
We haven't even got to the realm of divorce law. It doesn't work like
Indeed.
that. There's no debt and
No?
mistaken payments there.
All
No.
right. So is it a gift or not?
Well, in divorce, it's shared.
Yeah. All right. May I now invite Adjunct Professor Kim to accompany Professor Dato Elizabeth Lee to present a token of appreciation to Professor William Swadling. We have a commemorative teapot to celebrate the Lancaster University and Sunway University's partnership for the 20 years. Another example of our transboundary national or transnational education partnerships representing Sunway University's growing self-sufficiency, but the realization that we live in a multipolar world where it's better to be doing things together. All right, we will now proceed with the official group photograph, and students in the adjacent room, you also can join in. Yeah. All right, okay, let's, can I have you all back on the seats? Yeah. I see some empty seats. Would you mind if you can actually close the empty seats, because I'd like to have, and some of you that are standing, maybe you want to come in, yeah? Okay. There's one seat over here as well. There's two seats in here. Jade, come along. Have a seat in the middle. Yeah, center here. Okay, great.